We're back on the record in cause number 2020 CR 3856. Mr. Guajardo, I was explaining to you that the true bill of indictment alleges the offense of injury to a child, and I was asking you if you understand the charges that you are facing this morning.
Yes, ma'am.
Okay. If you take a look at the screen, I'm going to show you a document called the Court's Admonishments. Here we go. The Court Admonishments explains to you the range of punishment that applies to this charge, as well as several of your constitutional rights. The range of punishment in this case is a third-degree felony, and it's punishable anywhere from 2 to 10 years in the Texas Department of Criminal Justice and up to a $10,000 fine. Let's start with that. Do you understand the range of punishment that applies to your case?
Yes, ma'am.
Okay. Are you a citizen of the United States?
Yes, ma'am.
If you were not, I still have to advise you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. I want to go over your constitutional rights. You have the right to a jury trial. You have the right to remain silent, and you have the right to cross-examine all the witnesses against you at trial. Those are your constitutional rights, Mr. Guajardo. Do you understand that?
Yes, ma'am.
When you sign this document, what you're telling me is you want to give up the rights that we just went over. Is this your electronic signature on here?
Yes, ma'am.
Okay. And are you satisfied with the representation of your attorney?
Yes, ma'am.
Ms. Corley, does your client have a rational and a factual understanding of the proceedings against him?
I believe he does, Your Honor.
Has he been able to assist you in the preparation of any defenses?
He has.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
I believe he is, Your Honor. I haven't seen any evidence otherwise.
Okay. I will accept the waiver of rights and make it part of the record. Mr. Guajardo, if you take a look at the screen, I'm showing you the plea bargain agreement that you've made this morning. I'm going to go over this with you, and then I want you to tell me if this is your understanding. The agreement calls for a $1,500 fine. The state is recommending deferred adjudication for a period of 5 years. They also are recommending that you take a parenting class, an anger management class, and that we perform a TAP evaluation and follow the recommendations. There's also a no contact order with Julian Guajardo and Adriana Luna. Is that a true no contact, or is that a no harmful or injurious?
It's outside the agreement, Judge. We need to discuss it.
Okay. Is this going to be a PSI since it's recommended, or no PSI?
I don't think we need a PSI, Your Honor.
All right, we'll talk about it in a little bit. Mr. Guajardo, is that your understanding of the plea bargain agreement, sir?
Yes, ma'am.
State, is that yours?
If you said state, yes, Judge, but we did agree to probate the $1,500 fine after the paperwork was created.
Okay, the $1,500 fine will be probated. Ms. Corley, is that your understanding of the plea bargain?
It is, Your Honor. We just wanted to have a conversation short about the no contact order, and I hadn't talked to the state about this, but I had a question about the parenting class. I can do that after.
Okay, so everyone, this is your understanding of the agreement, correct?
Yes, it
Yes.
is, Your Honor.
Yes, Judge.
Okay. Mr. Guajardo, what is your plea to the charge of injury to a child? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest because you've talked about this matter with your attorney and you believe that entering this plea of no contest is in your best interest?
Yes, ma'am.
Are you doing this freely and voluntarily?
Yes, ma'am.
Has anyone forced you to enter a plea of no contest today?
No, ma'am.
Has anyone offered you anything in exchange for your plea?
No, ma'am.
I will accept your plea of no contest. I find it's voluntarily made, and I will ask the state to tender its proof.
State offers States Exhibit 1 and attachments.
No objections from defense, Your Honor.
State's one is admitted. Ms. Corley, are you satisfied the state has complied with Article 3914 in this case?
They have given me everything that I know of, Your Honor.
I will sign the discovery acknowledgement and make it part of the record. How old is the baby now?
I don't have the birth date right in
He's,
front of me. How old is Ethan?
he's 10 months old.
If you find that the evidence is sufficient to substantiate your guilt, talk about, I'm not going to make any other findings at this time, but let's talk about the no contact order, please.
Yes, Your Honor. So I understand there is an agreed 2-year protective order in place already. So we just wanted to, after that protective order has run the 2 years, we want to be able to come back to the court to request that it be changed and to have a hearing on the civil side as far as any kind of visitation, whether it be supervised. We want to make sure he has that ability. And so to that end as well, the parenting class, I think would probably be better suited if the court would agree to hold it in abeyance. And after the 2-year period, if he is able to get supervised visitations or some kind of visitation scheduled, that would be a more appropriate time for him to take the parenting class than taking it now and then waiting for 2 years and then being with the child. I think having it fresh would probably be more appropriate.
Why isn't he going to have supervised visits now?
Well, I was not involved in, apparently a protective order was filed and I was not involved in that case. And he signed a protective order, including his child for 2 years. So it was already done.
Yeah.
And
Well,
that was unfortunate.
You can always go back to civil court and ask to amend that. I mean,
Yes.
even some of the most violent offenders have access to their biological children on a supervised, very limited supervised basis.
Yes, Your Honor. So we just wanted to keep that in mind with the court, so that if we can make arrangements to do that, we're able to.
All right.
And
Go ahead, State.
sorry, Judge, the state is not opposed to supervised visits. Really, the no contact order is, we're asking for it because of the protective order. Because the mother sought the protective order and wants the protective order, felt the need for the protective order, we want to, back her up on that. So, if a court approves supervised visits, we are not opposed to that, absolutely.
All right. Well, the way that I'm going to phrase the terms of this probation is that the contact with the child is going to be subject to whatever family court order is in place at that time. So right now, what's in place is the protective order. In 45 days, there could be a different order. It's going to be your responsibility, Mr. Guajardo, that if that order changes, that you need to give it to your probation officer so that everyone knows what is applicable at that time. Do you understand?
Yes, ma'am.
Thank you, Your Honor. That will work perfectly.
All right, so having found that the evidence is sufficient to substantiate your guilt, I will make no other findings at this time. I will grant the application for deferred adjudication for a period of 5 years. $1,500 fine will be fully probated. I do want you to take the parenting class. I don't want you to delay that because that's only going to make you more ready to have access to any child. Anger management course, you have to take that right away. We're going to do a TAP evaluation. And I want you to, and probation, send me the report of the results of the TAP evaluation. I mean, it doesn't seem like there's any drug use. It doesn't seem like there's any issues, but let's just send me the results when they're done. It's just a survey, Mr. Guajardo. They ask you a lot of questions about your drinking patterns and stuff like that. So just answer it honestly. The results are going to come back to me. That's the order of the court. Mr. Guajardo, if you take a look at the screen one more time, this is, I apologize. The contact with the child, and I'm only going to change that one part. So contact with Julian Guajardo is subject to the family law order. And it's subject to the family law order in place and as modified. Contact with, what was the mother's name? Her last name was Luna, right?
Yes.
State? Okay, what is her?
I'm like, I have it up, Judge. I'm trying to get there. I'm sorry.
What's her first name, Stephen?
Adriana.
Adriana. Yeah. So contact with Adriana Luna is subject to the protective order. So it sounds to me, Mr. Guajardo, that you are to have no contact with Adriana Luna or Julian until Ms. Corley gets a different court order that allows you access And then once that happens, you'll have a way to communicate with both of them that doesn't violate the protective order. That's the goal. This is a plea bargain case, Mr. Guajardo. I did follow the plea bargain agreement. You do not have a right to appeal this decision. Do you understand?
Yes, ma'am.
Okay, I'm going to put you in a breakout room with the probation department. They're going to give you some